I'm very pleased to have been invited to give this lecture. I think it's about a very important subject which goes to the heart of how our society treats people with mental illness. There's probably no more unpleasant task for a psychiatrist than imposing treatment on an unwilling patient, and probably no experience for the patient that is more humiliating. Yet few would argue that involuntary treatment is never justified. It's the nature of those justifications that I shall be talking about. I will argue that conventional forms of mental health legislation that govern involuntary treatment, such as we have in this country in the Mental Health Act, discriminate unfairly against people with mental illness. Indeed, I will maintain that there is no reason for any form of legislation specifically formulated for people with mental illness. I will then propose a remedy to the discrimination that I hope to be able to persuade you exists currently. So, how is involuntary treatment governed? In many jurisdictions, the circumstances in which medical treatment may be provided against the patient's will is governed not by one set of legal principles or regulations, but by a number. Quite distinct legal regimes operating in parallel with different principles, different rules. England and Wales is a good example of this. Involuntary treatment of physical conditions and the involuntary treatment of mental conditions are governed quite differently. The former under the Mental Capacity Act, and I'll say a little bit more about that later on, the latter under the Mental Health Act. Consider now two patients, Ms. A and Ms. B. Ms. A is a 47-year-old lady with stage 2 cancer of the cervix. Her doctor recommends treatment involving radiotherapy combined with chemotherapy. He informs her that the likelihood of survival with treatment is around 60% at 5 years. Without treatment, less than 20%. Ms. B decides that she could not, under any circumstance, tolerate the adverse effects following treatment, especially the nausea and vomiting, symptoms that since childhood she has dreaded, and the fairly high likelihood of genitourinary complications, which she finds totally abhorrent. She rejects the treatment after a full discussion where she clearly understands the consequences of having the treatment and not having the treatment. Although her life may be at stake, Ms. B cannot be involuntarily treated. That's Ms. A, sorry. Ms. B is a 47-year-old lady who has a 20-year history of schizophrenia. When ill, she has the delusion that she's related to the Queen, and this results in a number of very bizarre and quite damaging acts on her part. She also neglects her physical care to the point that her hair becomes so matted that it can't be combed out. She's had over 5 admissions in the past, always following discontinuation of her antipsychotic treatment. And indeed, she responds quite well to those antipsychotic drugs when in hospital. On her last admission, again following a good recovery from her illness, medication was discussed. She said she didn't want to take it on a continuing basis. She understood the consequences of not taking it, the likelihood of relapse, the severity of the symptoms, the likelihood of readmission, probably on a compulsory order yet again. However, she explained that her sole social activity was membership of a sewing group in which she excelled in embroidery. All the antipsychotic medications she tried, and that was at least 4 different drugs, because of their neuromuscular side effects, made it difficult for her to sew. She said that she valued that social interaction more than remaining symptom-free. However, under the Mental Health Act, she could nevertheless be lawfully treated involuntarily. I didn't treat her involuntarily, and she's not a real patient, she's a composite. So in the common law world, as in England, a mental incapacity, or guardianship scheme is another term for it, such as our Mental Capacity Act, tends to be the preferred legal vehicle for the treatment, involuntary treatment, of people with a physical disorder. And mental health legislation, or civil commitment, I'm going to use both terms interchangeably, such as our Mental Health Act, is used for people with a mental disorder. And quite different legal criteria apply. So, in the treatment of a general medical condition, the involuntary treatment is only possible if the person lacks mental capacity or competence, the capacity to make treatment decisions. That's a functional criterion. I'll explain this in a moment. And that is then linked to the notion of the patient's best interests. So treatment is only possible for the patient who lacks capacity, and treatment is in their best interest. I'll explain those terms in a moment. Whereas the criteria for the Mental Health Act require some concept of mental disorder or mental illness linked with a risk criterion, that the person is at risk in terms of their own health or safety, or a risk to others. I'm going to argue that these arrangements discriminate unfairly against people with mental disorders by subjecting them to less favourable treatment under the law than those who don't have mental disorder, and this situation needs to be remedied. How does it discriminate? A patient with physical disorder, such as Ms. A, as I said, may refuse treatment even if it's life-threatening. UK courts and other common law jurisdictions set a very high value on autonomy, and I'm using that term loosely, but synonymously with the right to self-determination of what should be done with one's body. A mentally competent patient has an absolute right to refuse treatment no matter what the consequences, even if they're serious, and even if an apparently prudent person would choose to have that treatment. We accept this decision unless there's reason to believe that the person lacks capacity, as I've explained. Paternalistic interventions in medicine, with the notable exception of psychiatry, override the individual's autonomy only if, 1, the patient lacks capacity, and 2, the treatment is in the patient's best interests. So what do I mean by capacity? Capacity involves the patient's ability to understand and retain information about the nature of what it is they're suffering from and the nature of the treatment that's being proposed, why it's being proposed, the consequences of having the treatment or not having the treatment. Being able to weigh up that information and being able to express a choice. The patient accepts that the information is relevant to the patient's predicament. They don't need to accept the exact details of the diagnosis, but that there is a problem that the doctor believes merits treatment. And the person is able to consider the consequences of having the treatment or not having the treatment for their lives in the light of their values and their life choices. Best interests, the other element, attempts to determine what the patient might have chosen under these circumstances if the patient did have capacity. So there are ways of determining this. One may be an advance statement or an advance directive that the patient makes, which specifically says what treatment they would prefer or refuse under these circumstances. Or there may be a general statement of values or preferences. They may designate a person to act as a substitute decision maker, and so on. But the point here is that the patient's values are accorded special weight. Mental illness is an anomalous position here, as you've probably worked out. This kind of legislation involves no role for decision-making capacity in the initiation of detention or initiation of treatment in most jurisdictions. There are examples, but the vast majority of jurisdictions, decision-making capacity plays no role. The Mental Health Act, for example, allows involuntary treatment if the person is suffering from a mental disorder, extremely broadly defined, and including personality disorder, whatever that may mean. That is of a nature or degree which makes it appropriate to receive medical treatment, and treatment is necessary in the interests of the health or safety of the patient or for the protection of others. That's what Section 3 of the Mental Health Act says. You see, it's very different to the situation for a patient with a non-psychiatric illness. So, staying with the health or safety of the patient for the moment, compared to those tests for those with physical disorders, the criteria for the involuntary treatment of mental disorders fail to respect the autonomy of the patient. The patient's reasons for rejecting the treatment are not required to be explored. Obviously, a good psychiatrist will explore them. Nor explicitly is the question of whether the treatment is in the best interest of the patient in the sense in which I've discussed best interests. The key considerations are the presence of a mental disorder, the risks to the patient's health or safety, and these are presumably from the perspective of the clinician or the treatment team or other representatives of societies, but not specifically the patients. But we accept that patients with physical disorders, provided they have capacity, can make decisions that may be seriously detrimental to their health or safety. For those persons, their personal values are given dominion. Those with mental disorder are not accorded the same privilege. Why is this so? How has this arisen? Well, there seems to be an underlying assumption that mental disorder necessarily entails some incompetence, some incapacity. That a person with mental disorder, one doesn't need to ask, they are not fully capable of thinking through and making a rational judgment about what is in their interests. But we know from excellent research that around 50% of patients admitted to an acute admission ward in a psychiatric hospital, so these are the illest patients, about 50% of them retain decision-making capacity in the way that I've defined it. So by failing to respect the mentally disordered patient's autonomy, by not presuming capacity unless there is reason for doubt, by assuming that mental disorder entails incapacity, by enshrining these prejudices in legislation which applies uniquely to those with mental disorder, current mental health legislation discriminates against those with mental disorders and serves to stigmatize them. They are assumed to be not fully persons with agency or the capacity for self-determination. Now, when it comes to protection of others, if anything, I think things even get worse. Mental health legislation usually confuses paternalism and protection of others. Remember, I talked about the health or interests of the safety or for the protection of others. These are usually coupled in legislation. But they're quite separate ends. The former is concerned with the health interests of the patient and empowers others to act when the patient cannot act, himself or herself, in their best interests. On the other hand, the protection of others turns on the risk of harm. The risk may not have much to do with the patient's capacity to make treatment decisions at all. Where does the discrimination lie? People with mental disorders are unusual in being liable to detention, yes, in hospital usually, because they're assessed as presenting a risk of harm to others, but without actually having committed an offence. This is best illustrated with this diagram, and I have remembered to bring a pointer with me. So this blue circle shows all the people at a particular point in time who are risky in the community. And the red circle are all the people with mental disorder at a particular time in the community. And there you see this area of overlap, and this is not drawn to scale. It's actually a very small area. I'll come to that in a moment. But it's this group of people who are uniquely liable to be detained on the basis of risk, not on the basis of having committed an offence. Now, these risky persons include people like people who abuse their spouses regularly, who drive recklessly, who are easily provoked to anger and to aggression by intoxication or various situations that may arise in pubs or other places like that. Now, if one were to think about non-discrimination here, one would have to say that if all of these people are equally risky, and I'm making a huge assumption here that one can actually ascertain riskiness accurately, that's absolutely not true, but let's assume, for argument's sake, that all of these people are equally risky, all of those people in that thick circle. Does it not follow that fairness or justness will require that all of those people should be equally liable to detention on the basis of that risk? So either there are two non-discriminatory possibilities here. One is that we have generic dangerousness legislation, which would mean that all of those people in the blue circle who exceed a certain threshold, which is regarded as acceptable in our society in terms of the risk they present, all of those, action is taken. If they have a psychiatric problem which requires treatment, that might be something that will be offered to them, or they might be compelled to have it if they lack capacity that's in their best interests. Or if they don't have a mental disorder, there may be other treatments, in inverted commas, that are effective. Anger management may be very effective for people who are abusing their spouses regularly or easily provoked to anger and to violence. Or the alternative is not to have any dangerousness legislation for anyone. That is, that on the basis of risk alone, no one should be detained. So I'm not arguing for one or the other, although I would favour the latter. But if one is going to have non-discriminatory legislation, that either preventative detention is something to which we are all going to be equally liable, or none of us are going to be liable to it. You can't just have it for the mentally ill person. So the mentally ill person with capacity should not be treated involuntarily on account of risk to others. By definition, such a person understands the consequences and risks that their illness entails and takes responsibility for them. But I'm not arguing that risk to others is not important. If a patient lacks capacity and treatment is in his or her best interests, non-consensual treatment is, on the account I'm giving, entirely justified. For such a person without capacity, the risk to others would be taken into account, particularly in the consideration of what is in their best interests, and might prompt particularly urgent action if there is a serious and imminent risk to the patient or to others. Again, why has this situation arisen? Why do we have this particular kind of discrimination for people with mental disorder? And again, I think it represents a stereotype that we have in our society that, of course, people with mental disorder are dangerous. They're unpredictable. They present a risk. You know, one doesn't need to ask the question. It's just a question of how dangerous are they? But it's actually a very dangerous situation for these people and for society, because there is an extraordinary tendency for society wanting to deal with people who are a nuisance and who are troublesome and worrying in all sorts of ways by expanding this circle, making it larger and larger, the mental disorder circle. So that we had, for example, the Home Office a few years ago proposing a new state-defined diagnosis, not one that doctors have ever recognized, called dangerous severe personality disorder, in which it was argued that people who have dangerous severe personality disorder should be able to be detained indefinitely on the basis of risk, even if no treatment was available. So there's a troubling aspect to this situation, that is the ever-expanding nature of that circle, depending on what society finds disturbing or worrying. Well, what about violence and mental illness? I'm just going to digress a little bit here and say that some people say, well, you've got to have separate mental health legislation because mental illness is different from physical illness because it's associated with violence. And a lot of people make this point. So what is the relationship between mental illness and violence? It's true that dangerousness may be a consequence of mental illness in a small minority of patients. However, the risk in the absence of alcohol or substance abuse or antisocial personality is somebody who acts in an antisocial way. It's a totally circular definition. But the risk in the absence of those is actually modestly, if at all, raised compared to the general population. 2 recent population studies have shown that. If one were to completely abolish mental disorders, so it just didn't exist at all, the fraction of serious violence in society that would be reduced would be in 5% or less. Violence is no more predictable, as far as I can see from the literature, in those with mental illness than in those without. In fact, the predictors seem to be the same in both groups. Nor is the propensity for violence more treatable in those with mental illness. It's quite possible, as I said before, that some kind of psychological or group intervention for non-mentally ill violent people might be more effective than the treatment of a violent propensity in somebody with a mental illness. I mean, the fact that there are people in Broadmoor for 20 years suggests that actually mental illness may not be that easy to treat in some cases. So again, justice demands that all people who are equally risky should be treated equally and equally subject to preventive measures that society may see as appropriate. Just briefly about compulsory treatment in the community. This is a recent development in most jurisdictions. It's been taken up in most jurisdictions now, and it's regarded as an appropriate measure when the locus of treatment has shifted to the community from the hospital. It's been a controversial measure, however. Now, according to my analysis, I would conclude that it is appropriate and acceptable for somebody to be treated involuntarily in the community if they lack capacity and such treatment's in their best interests, and that treatment can be provided safely and effectively in the community. However, it should end when the person regains the capacity to make treatment decisions. So it would, I think, exclude quite a large number of patients who are currently on community treatment orders as a kind of prophylactic measure to prevent them discontinuing medication, to prevent them relapsing and then being risky in some way. So I conclude that conventional mental health legislation, as in this country, discriminates against people with mental disorders. It reflects stigmatizing stereotypes. Autonomy, or the right to self-determination, is not respected. Preventive detention is unfairly applied to this group. The two-track approach, one set of rules for the mentally disordered, another for the rest of medicine, is inconsistent with the principles of healthcare ethics and with basic notions of human rights, especially freedom from unnecessary discrimination in the law. So some other form of legislation is required. So I think it was greeted positively by many people when the previous government said, well, we need a root and branch reform of mental health law. The kind of practice has changed since 1983, or really essentially since 1959, because the 83 Act was not that different in principle from the 1959 Act. That sounded very reasonable. But given the case I've presented, I must say that it has been bitterly disappointing that the government paid scant regard to the discriminatory nature of mental health law in this country, and that a wonderful opportunity for significant reform was lost. So you probably know a protracted process lasting almost 10 years in which there was an initial groundbreaking report in many ways from the Richardson Committee, whose recommendations were almost totally rejected. Then followed green and white papers and 2 mental health bills. Finally, in 2007, the government abandoned those and opted for amending the 1983 Mental Health Act, and the major innovation there was the introduction of community treatment orders. Criticism of the government's proposals were vociferous and sustained, and we can claim a world first here, that nearly all the stakeholder groups, patients, doctors, nurses, social workers, lawyers, carers, were all united in opposition to the government's proposals. Most saw the proposals as privileging public protection against promoting the health interests of patients. The inclusion of a capacity or impaired decision-making criterion was supported by most of the stakeholder groups, but was resisted by the government. What was interesting was something quite fortuitous, that at the same time the government was providing in a statutory form what had previously been the common law relating to the treatment of people with physical disorders who lacked the capacity to make decisions for themselves. So at the same time we had the Mental Capacity Act. So we now have these 2 pieces of legislation, as I mentioned at the very beginning, the Mental Health Act for those with mental disorder, the Mental Capacity Act for those with physical disorder. It can be very confusing because the Mental Capacity Act actually applies to people with mental disorder as well, unless they fall under the criteria of the Mental Health Act, in which case the Mental Health Act trumps the Mental Capacity Act. But you might have a patient who lacks capacity, who has both a mental disorder and a physical disorder at the same time. Not uncommon. So the mental disorder is covered by the Mental Health Act, the physical disorder in the same patient is covered by the Mental Capacity Act. Quite different rules. Now, what if the mental disorder is a significant contributor to the physical disorder? Not unusual, following an overdose, possibility of liver damage from paracetamol. Or the physical disorder is a significant contributor to the mental disorder. it gets terribly confusing. Not an uncommon situation either, I must say. Okay, so is there a solution to this problem? Well, because mental health legislation discriminates in the manner I've discussed, Professor John Dawson and I, John Dawson is a professor of mental health law in New Zealand, we've proposed a single law in which there's no need for specific reference to mental disorder, nor is there any need for any separate legal regime, we argue, focused solely on involuntary psychiatric treatment. We propose one comprehensive involuntary treatment statute based on the capacity test, like in the Mental Capacity Act, coupled with best interests. And that applies in all healthcare settings for all people who lack the ability to make treatment decisions for themselves, no matter what they suffer, whether it's a physical disorder or a mental disorder. In our view, there is little evidence that impairment of patients' capacity in these two kinds of disorders differs in any significant way. They can be as reliably ascertained from research that I've been involved with colleagues. And that we believe that legal criteria that are sufficiently inclusive to cover the full range of situations can be devised. We've therefore made proposals for such a fusion law, and I'll explain why we call it a fusion proposal in a moment. And we've actually drafted with Dr. Rowena Dorr a model statute to show that one can give practical expression to this kind of single comprehensive statute. So this scheme would cover the treatment without consent of all medical conditions in all healthcare settings, avoiding the problematic distinction between physical and mental disorders. Now, the law already requires psychiatrists and others to assess the capacity in people with mental disorder. There is some part of the Mental Health Act where this is required, but more importantly perhaps is that often psychiatrists are asked to assess the capacity of somebody to manage their property or to make a will or to stand trial. So capacity is an important element of medical practice, but excluded from psychiatric treatment, as I've said. So the aim of our proposal is to reduce discrimination against people with mental disorders by not making psychiatric treatment unnecessarily the subject of special legislation, and instead applying consistent principles concerning involuntary treatment across all fields of medical law. Now, one might suppose that the Mental Capacity Act would be just fill the bill for this kind of legislation. Well, unfortunately, on its own, it's not adequate. Although the Mental Capacity Act strongly respects autonomy, it is counterbalanced by a serious weakness, and that is it doesn't pay sufficient attention for the fusion proposal, and I would argue actually in practice now, for the regulation of emergency treatment, forced treatment and detention. For example, the Mental Capacity has one section only out of 69 that deals with the use of force. And this deals with restraint, and it says that restraint is permitted when it is a proportionate response to the likelihood of the patient suffering harm and to the seriousness of that harm. And that's essentially what the Mental Capacity Act says. But detention and the use of force are exactly those areas where civil commitment legislation, the Mental Health Act, are very strong. It defines who has the authority to say that somebody should have involuntary treatment using force, where they should be detained or where they can be detained, for how long, who authorizes it, what is the review process. These important elements of regulation for the use of force. Now, it's rarely pointed out that the lack of clarity around the use of force is actually quite important for the treatment of people with incontrovertible physical disorders. So one has people with physical disorders who object to treatment and who lack capacity. Now, under the Mental Capacity Act, they can be treated if the use of force is proportional. But it's not uncommon at all. I've on many occasions been asked to put a patient on a section of the Mental Health Act because a policeman or an ambulance officer or a surgeon feels unhappy about forcing the person to have treatment. And it's to do, I believe, with a lack of clarity around the regulation of the use of that force. And there's another side to this, which is very rarely mentioned, that is that there are objecting patients who I would judge as lacking capacity, who might benefit from a treatment, who are not given the treatment, because clinicians may reduce the threshold for capacity, because if the person is judged as lacking capacity, objecting, the use of force, again, it's so unclear about how this is to be regulated, how someone is to be detained and for how long. So I would argue that clarity around the use of force is of significance for both patients who fall under the mental disorder rubric as well as the physical disorder rubric. So that's why we believe a fusion of the best that both the mental capacity kind of legislation, mental health legislation, has to offer. We bring those together, legislation based squarely on capacity and best interests, but with due attention to detention, use of force, that is the kind of non-discriminatory law that we support. Now, it might have occurred to some of you that Dawson and I could have proposed an alternative form of non-discriminatory legislation. That is the application of the rules governing mental illness to people with a medical disorder. So just imagine that you go and see the doctor, and the doctor says, well, this is the treatment that you should have, and you decide, having thought about it, and with full capacity, that actually this is not the treatment that you would prefer to have. The doctor says, well, look, I'm terribly sorry about this. You've got this medical disorder. It warrants treatment. In my opinion, the treatment is in the interests of your health or safety or for the protections of others, and therefore you're going to have it. I don't think many people would find this an acceptable option, so that is not the non-discriminatory option that we're proposing. Okay, right, doing quite well for time. Now, I believe that our proposal is also consistent with a new instrument which is on the landscape of rights of persons with disabilities. And this is the United Nations Convention on the Rights of Persons with Disabilities. It was passed by the General Assembly of the UN in December 2006. It's now been signed by over 140 countries and ratified by 60, including the United Kingdom. So what is this convention? Well, the convention is a very interesting instrument. It comprises the classic set of liberal political rights, freedom, right to liberty, integrity of the person and so on, freedom from torture and inhuman treatment. It also includes the human rights that have come into prominence since World War II, such as the right to a home and family life, the rights to health. But it also includes another set of rights, the socioeconomic rights that are especially relevant to people with disabilities. The right to independent living in the community, community inclusion, the right to work and employment, and the right to be free from exploitation and abuse. But I should say that long-term mental illness, at least long-term mental illness, is clearly included under the rubric of a disability, although the definition of disability in the Convention is actually not very precise. But it seems quite clear from parties who've been involved in the establishment of the Convention that long-term mental illness, at least, is included as a disability. And if it is, then the Convention is especially challenging, through various articles I'll come to in a moment, in its implications for involuntary treatment. In fact, this is what the Office of the UN High Commissioner for Human Rights says, and I'm quoting him here. Article 14, paragraph 1b of the Convention unambiguously states that, he quotes, the existence of a disability shall in no case justify a deprivation of liberty. Proposals made during the drafting of the Convention to limit the prohibition of detention to cases solely determined by disability were rejected. So there was an argument, well, look, yes, we will exclude those cases maybe that are just solely disability-based. No. As a result, he goes on to say, Unlawful detention encompasses situations where the deprivation of liberty is grounded in the combination between a mental or intellectual disability and another element, such as dangerousness or care and treatment. Such measures are partly justified by the person's disability, and they are thus considered to be discriminatory and in violation of the prohibition of deprivation of liberty on the grounds of disability, and the right to liberty on an equal basis with others prescribed by Article 14. So he's saying that disability, if it forms one arm of the criteria necessary for involuntary treatment, excludes that the acceptability under the Convention of that form of involuntary treatment. Now, some commentators maintain that involuntary treatment of a person with a disability is effectively excluded altogether, and that we need to have another model of support and helping the person to achieve their preferences. However, it's very difficult to see how one could entirely eliminate the need for involuntary treatment for those who lack capacity and where treatment's in their best interests, I would argue. I know of no society that doesn't accept this justification in some way, that involuntary treatment is justified. So what conditions would need to be satisfied for involuntary treatment to be justified under the Convention? Well, I think there are three that appear key to me, and I'm not a lawyer, I have to emphasize. The first is that there must be, quote from Article 3, respect for the inherent dignity and individual autonomy of the person, including the freedom to make one's own choices. Secondly, there must be no discrimination of any kind on the basis of disability. And thirdly, the person must, under Article 12, quote, enjoy legal capacity on an equal basis with others in all aspects of life. Now, clearly, mental health legislation violates these principles. Mental disorder is a status, is regarded as a disability, and therefore it forms the first criterion for involuntary treatment, and it must rule out the current provisions under Section 3, for example. It's coupled with a risk criterion, exactly what the High Commissioner was saying was not adequate. And furthermore, involuntary treatment can be given without taking into account the patient's capacity to make treatment decisions, so they're not enjoying legal capacity on an equal basis with others in all aspects of life. So clearly unacceptable. Okay, now recall that the legal scheme under the Fusion proposal has the loss of capacity for decision-making as its central entry point into consideration for involuntary treatment. Some people might say, actually, but isn't that a disability, and therefore doesn't that exclude the use of capacity as a criterion under the Convention? Well, I would argue that it doesn't. I would argue that capacity is conceptually distinct from disability. It's in the vast majority of cases specific to a specific decision. That capacity is a functional assessment of the person's ability to make a specific decision, to be able to make a will, to be able to manage their financial affairs, to be able to understand the implications of admission to hospital, to make a decision about taking a medication. And it's not long-term in the vast majority of cases. And it may occur in any person. It may occur irrespective of any previous disability they had. So a young person who's had a road traffic accident and sustains a head injury and says, nothing wrong with me, and they have a hemorrhage which is gradually impairing their level of consciousness. That is a person who's been perfectly well, who now lacks the capacity to make a treatment decision. And indeed, elderly people with a chest infection may become confused and unable, and lose capacity and be unable to make treatment decisions, whereas without a chest infection, all their cognitive functions are perfectly intact. So there's good reason to separate capacity to make treatment decisions from disability, even though both may be present at the same time in the same person. But in most cases, they occur separately, and they're conceptually distinct. So remember, an important element of the fusion law is that it is driven by the need to avoid discrimination, that it applies to all persons, no matter what the cause of the impairment of capacity, whether it's a mental disorder or a physical disorder. It's an event that may be suffered by any person, whether they have a pre-existing disability or not. So on that basis, I would argue that the fusion law proposal is compliant, consistent with the Convention on the Rights of Persons with Disabilities, if we accept that people with mental disorders have a disability, whereas the Mental Health Act, I think, clearly is not compliant. I don't have the time to discuss the fusion proposal any further. In the transcript of this lecture, there are some references there, which, if you're interested, you can look up. But I'm just going to finally conclude that mental health legislation, as currently conceived in most jurisdictions, discriminates against people with mental illness. It carries underlying assumptions that people with such illnesses are not fully autonomous and that they're dangerous to others. Thus, such legislation reinforces damaging stereotypes of people with mental illness. By building on the complementary strengths of capacity-based and civil commitment legislation, we propose a fusion of legal principles into a model law which has decision-making capacity at its centre, but which clearly defines how the use of detention and force are to be governed. This comprehensive law is designed to apply to all persons who lack capacity from whatever cause, in whatever healthcare setting. We've drafted a model law that demonstrates that these principles can be given practical expression, and that this model law, unlike the current Mental Health Act, is, I would argue, compliant with the UN Convention on the Rights of Persons with Disabilities. So, thank you very much.